CRJ 225. This is your Section 4 podcast where we're going to talk a little bit about homicide and revisit assault and battery in a little greater detail. Now, I've asked you to read some documents I provided under modules, and hopefully you've done that, including these statutes. So if you haven't done that, stop and go read those things because they're relevant to what I'm going to talk about, and it's going to help you. It's a building block approach. It's going to help you as you hopefully learn, gain knowledge, and retain what I'm going to talk about. So let me give you some homicide high points. Illinois homicide statutes break killing another human being into 5 different offenses found at 720 ILCS 5/9 at sec. I'm going to go through each of those. First-degree murder. The essence of first-degree murder is an intentional killing or knowingly performing an act that leads to the death, even if death was not completely intended. Felony murder is the next category. It's a death that occurs during the commission of a felony offense, and it's referred to as felony murder in Illinois, and you've heard about felony murder already in this course. The next category is second-degree murder, and second-degree murder is not a lesser included offense of first-degree murder. It is a lesser mitigated offense. We've talked about the aggravating and mitigating factors that you become familiar with as you've begun to look at the actual criminal offense statutes. So this is a lesser mitigated offense of first-degree murder. And a conviction of second-degree murder lessens or mitigates the sentence after a person has been found guilty of first-degree murder. It's not an acquittal of first-degree murder. Rather, second-degree murder is an acknowledgement that a person may have acted under certain circumstances that society is not prepared to excuse as a complete defense, but it does allow for a lesser sentence. And then finally, involuntary manslaughter. Involuntary manslaughter is an unintentional killing. It results when a person acts recklessly, such that their conduct leads to the death of another individual. The difference between involuntary manslaughter and first-degree murder is the mental state that accompanies the act that causes death. First-degree murder requires an intentional or knowing act that creates a strong probability of the death or great bodily harm of someone. Involuntary manslaughter requires reckless conduct that is likely to cause death or great bodily harm to an individual. And then an offshoot of involuntary manslaughter is reckless homicide. And in Illinois, involuntary manslaughter and reckless homicide are essentially the same offense. But a reckless homicide refers to a death caused by the use of a motor vehicle. So in other words, reckless conduct while driving a motor vehicle that is likely to cause death or great bodily harm to an individual would be, and then a death does occur, would be a reckless homicide, not an involuntary manslaughter. Again, no intent. There wasn't intent. It wasn't first-degree murder, an intentional or knowing act that creates a strong probability of death or great bodily harm. This is dumb to the point of egregious stupidity, reckless conduct. Let's talk about the sentencing classification. In Illinois, first-degree murder has its own special classification. It's a Class M felony, and it's normally punishable from between 20 to 60 years. However, special enhancements may also apply, as you've seen from reading the statute. Now remember, Illinois is not a death penalty state, but life in prison is a sentencing option. I always urge you to read the entire statutes, including the aggravating and mitigating factors, and to know how each of those applies to the sentencing or penalty options for murder or homicide, or any offense, really, right? Because you're going to find those aggravating and mitigating factors throughout the criminal offenses. And just one more comment on homicide, and a reason that you always want to go back and read the statutes. The statutes change as to the aggravating and mitigating factors, the sentences, where we are at any given point in society. I may have mentioned in this class, may have mentioned in the introduction or the orientation, at one point in my lifetime, I worked for the Illinois Attorney General's office in the Criminal Appeals Division, where a large part of what we did was to defend prosecutions throughout the state of people who were convicted of homicide. And at that time, we had a death penalty. At that time, we had death penalty cases that our office took all the way through the final appeals. If somebody could go all the way through the United States Supreme Court, we were the prosecutors of those appeals. We represented the state and argued for the death penalty, essentially. And then the death penalty went away. We also had all the other cases related to claims that people were improperly or wrongly imprisoned, sentenced, tried, etc. The law changes. It will change over the course of your career. It will change probably before you get into your career. So you know now at this point in the semester where to find the statutes, how to read statutes. You're getting more familiar and skilled with that. And you understand how to break down elements of a crime, the mitigating and the aggravating factors, all of that. How to find the sentence, to read how the sentences are put forth, etc. That's a skill you've developed now in the first half of the class. So take that skill with you to that next level. Take that skill with you through the rest of the class. Take that skill with you when you go on to another program, to a bachelor's degree or higher, law school, whatever, and your career. Give yourself a little pat on the back because you have developed that skill in the last few weeks in the first half of this course. Let's wrap up by discussing our old friends, assault and battery. Now, as we know, assault and battery are two completely different criminal offenses. There is no single crime known as assault and battery. The difference between assault and battery. When it comes to assault versus battery, the difference is that the assault occurs when a person is threatened or put in fear of getting hit illegally or getting battered illegally, getting harmed illegally. Now, typically, a battery is when physical contact with a person actually happens, and that contact must be harmful or illegal. And you may remember that I mentioned, um, somebody spits on you. Probably not going to do you permanent harm, probably not going to leave a bruise, probably not going to hurt you for very long, but it is offensive. It is potentially harmful. Somebody threatens to hit you, to spit on you, to do something offensive or harmful. That's the assault. The offenses are related, but they don't necessarily have to occur together. They often do occur. The assault occurs, and then the battery follows, but not always. The Illinois criminal charge of battery is listed under 720 ILCS 5/12-3, and the law says a person commits battery if he or she knowingly, without legal justifications by any means, causes bodily harm to an individual or makes physical contact in an insulting or provoking nature with an individual. So either causes bodily harm, and that's typically something that we can see. It manifests physical or has physical manifestations. Physical manifestations are typically, uh, a bruise, a cut, something we can see that may require medical treatment, right? Or they make physical contact of an insulting or provoking nature. And something that's of an insulting or provoking nature may not leave a physical manifestation. Something that requires medical attention may bruise, may show a mark, etc., right? A battery is when one causes harm, usually by making contact, or contact that is insulting or provoking in nature, like a slap across the face, may not cause harm, but it is insulting or provoking. A poke in the chest, that's seems to be the male go-to, I would say. Somebody gets up in your face and they poke you in the chest, you know, um, and that creates the provoking nature. The essence of battery is some kind of unwanted physical contact. Now, by comparison, we find assault just ahead of the battery statute at 720 ILCS 5/12-1, and it says a person commits an assault when, without lawful authority, he or she knowingly engages in conduct which places another in reasonable apprehension of receiving a battery. An assault occurs when one puts another person in apprehension of receiving a battery. The apprehension is from the perspective of the person who feels the apprehension, the person who is assaulted, not in the perspective of the person who assaults another. No actual contact needs to be made for an assault to occur. The essence of an assault is being put in fear of getting harmed, getting hit, having contact, having some harmful or offensive contact. Now, simple battery is a Class A misdemeanor. However, when you look at the aggravating factors, battery can be aggravated based on the status of the victim, the place or location of the offense, or the variety of other factors that are provided in the statute relating to how the battery occurred. So see the aggravation factors, and then it can rise to a felony by these aggravated factors. The same with assault. Simple assault, where simple battery is a Class A misdemeanor, so it's a couple levels up in seriousness. A simple battery, or assault, simple battery, did I say that wrong? Probably. If I did, let me reverse it. A simple battery is a Class A misdemeanor, and a simple assault is a Class C misdemeanor. So battery is a couple notches more serious. However, there are aggravated forms of assault also in the code. The assault can be aggravated by the same sort of status of the victim, the place or location of the offense, or the variety of other factors related to how the assault occurred. And again, always pay attention to the aggravation factors and the mitigating factors. Now, typically, those aggravating factors and mitigating factors may look a lot alike. But as you're going to see throughout this course, and we still have many more offenses to cover, some of the offenses are unique, and so some of the aggravating and mitigating factors may be unique. Some of the sentencing options may be unique. And we always, again, final commercial for this podcast, we always want to use our skills, the skills you have developed up to this point in the course, to go and look at the statute, to read the statute, not once, not twice, but thrice, and then do your best to be able to extract and pull out those elements. What's required to find that offense? And then for some of you, that means you're going to write police reports where you've looked at a set of facts, and based on your knowledge and your reading of the statute, you say, oh, this has occurred. It's an assault, not a battery, or it's a battery, and there was an assault. And you write your report so that the facts that you are told or you witnessed or you encountered in your investigation, those can be placed in your report in a way that tells a story that's consistent with the expectations of proving that case, the elements. You demonstrate through the facts what the harmful or offensive touching might have been, or what the thing was that caused the fear or apprehension, right? That's simple. We're at the midpoint already. So don't let up on your effort. Appreciate the skills you've developed, the knowledge you've gained. Keep building on those things, because this course is intended to drive you, propel you, to move you towards who and what you want to be in law and justice. So keep on earning those things and keep on moving. Onward. If you need me, you know where to find me.